Good morning, everybody. Thank you all for joining us. We're just waiting for the last couple folks to jump in here from the waiting room. And I think that's everybody for now. All right, well, thank you for joining us today for our weekly Zoom Q&A. I'm gonna start like I always do with some Zoom housekeeping tips. Starting with, we do ask that everybody stay muted during the Zoom. Just cuts down on background noise, makes it easier for everybody else to hear. Your audio and video buttons, in case you need to figure out how to mute or unmute yourself, are on your Zoom toolbar, which probably is at the bottom of your screen. You're welcome to be on video or off video, whatever works best for you today. And again, please stay muted, but you're welcome to unmute yourself to ask a question verbally if that's something you want to do during the course of the Q&A today. So just keep that in mind. The chat button, it might be flashing because I just put a message into the chat. The chat is the best way to ask questions during the Q&A today. It's not for, ongoing discussions and arguments about things, but if you need to ask a question or ask us to clarify something that we've said in the Q&A, feel free to pop your questions or clarifications in the chat. As we remind you every week, I want to remind you that we are not here to give legal advice. We are here to speak generally about legal stuff that we think is of interest and valuable information for community associations in Washington State and for all the folks that serve community associations in Washington. So if somebody sends you one of our videos or our blog or something one of us writes on LinkedIn or anything else like that in a public forum, and they say that you have to do something or you can't do something else because of something one of us has said in the Q&A or otherwise online, you can ignore them because this is not legal advice. Certainly you can use this information to get you pointed in the right direction, but if your community needs legal advice for any particular reason, the only place that you can get that is from your association attorney, who has an attorney-client relationship with your association, and also importantly understands the structure of your community, the content of your governing documents, the statutes that you're governed by, and all of the other things that are relevant to their ability to give you legal advice. Another reminder that we've just started giving folks recently is that we do reserve the right to reject questions for any reason, including when the question comes from an unidentified source. So you can hear us talk a little bit more about the reason behind that. 2 weeks ago in the video is when we first started making this announcement, but that is something that we are going to reserve the right to do going forward. And if you get a response to your email that says we are not going to answer your question because it's, too specific or asks for legal advice or whatever, please don't shoot the messenger. Chelsea is not the one who makes those judgment calls. I am, or Ken is. And it's just, we have to be careful about what we try to answer in a public forum like this because we can't, as I said earlier, give legal advice. We have also been reminding everybody weekly that WSCAI has a Wakaiowa resource guide for sale, and proceeds from the sale of that resource guide benefit the Legislative Action Committee, which does a lot of work trying to benefit community associations in Olympia, both during the legislative session, but also in the off season as well. If you're interested in learning more about the Wakaiowa Resource Guide, you can contact WSCAI by going to their website, which is wscai.org, and looking at their contact information there and reaching out to the chapter about that resource guide. Speaking of Wakaiowa, we have also been reminding everybody that some changes to Wakaiowa took effect in July of this year for existing Wakaiowa communities. But there are also some changes to our governing statutes that are taking effect in January of 2026, which is coming up pretty quick here now, less than 2 months. Those are primarily regarding meetings provisions and delinquency notices when accounts fall behind. We have been talking about these things a lot. We're going to start today with kind of a primer and a discussion of some of the meetings changes. And so if you want to look at our last maybe 2 months worth of Zoom Q&A videos on our YouTube channel, which is linked in the chat, you will hear a lot about those changes. And lastly, we have also been talking about, we're getting lots of inquiries from communities that are considering revising their governing documents because of some of the upcoming statutory changes. I think now that we're into November, the chances of effectively completing a revision to your governing documents, if you haven't even started, is probably unlikely before the first of the year, that is. It might be possible to get a revision to your bylaws completed if you are a community that does not require a vote of the ownership in order to pass a revision to your bylaws. So if your community really wants your bylaws to match up to the changes, for example, to the meetings provisions of the statutes, you would want to reach out to your association attorney pretty quick here and request a turnaround time and a quote for your bylaws revision only. Declaration revisions have to be recorded, require a vote of the ownership, notice to the ownership before that vote, et cetera. So the likelihood that you can accomplish an amendment to your declaration before the end of the year is probably pretty slim. But again, your mileage may vary, as they say, so check in with your association attorney if you are considering modifying your documents to make them more consistent with the upcoming statutory changes. I think that takes us through all of our announcements. So I'm going to go ahead and jump us into our first topic, which is prompted by a couple of questions that we got about meetings, working sessions, and the like. So the first question is, an article in WSCAI's recent journal stated that boards can hold working sessions without notice to the owners and without allowing attendance by the owners, so long as no voting or formal decisions are made. Is this true, and how would this be any different than an executive session where no formal vote is taken? I think this is not true. I think it is not only a violation of the statute, but it's very much a violation of the clear legislative intent behind these statutory changes. The legislature has made some really clear indications, both in the statutory language itself, but also in all of the negotiations previous to the bill that was passed modifying the statute, that they want as much as possible business of the association done in full view of the ownership. And what this means is they don't want email votes taking place. They don't want email discussions taking place. They want boards to have substantive discussion about the association's business and then votes on those issues in open board meetings where owners have the right to both participate in the owner forum at the beginning of the meeting, as well as just observe during the non-owner participation part of the board meeting. If the legislature wanted a broader array of topics to be discussed in private outside of the view of the owners, they would have modified the list of topics that are very clearly stated in the statute that are acceptable for discussion in executive session. There was already a mechanism in the statute that allows a board to adjourn from an open meeting to a closed executive session to discuss a very small subset of topics that the legislature recognizes could be private enough that their discussion in an open meeting might not be appropriate. Those things include things like personnel issues, if an association has an employee and their contract is being discussed or their conduct is being discussed. It includes things like confidential bidding of contracts that might harm the association if those things are discussed in open session. It includes things where there is a valid reason to suspect that somebody's privacy might be violated if the thing is discussed in the open meeting. The best example I can think of that is if you have an owner who comes to your board and appeals to have their address taken off the list of the ownership because their address is they participate in an address confidentiality program. There are address confidentiality programs to protect folks, for example, that are victims of domestic violence. That would be something where there's a reason to think that discussing it in open session might violate someone's privacy, right? But there's this list of topics that the legislature has already put into the statute where they say, there is this list of topics that we think could be better discussed in executive session. If the legislature had wanted to expand the list of topics where that kind of discussion takes place outside of the view of the owners, they would have just lengthened the list of things you can talk about in executive session. They did not do that. Instead, what they did was they made the Wakaiowa meetings provisions applicable to everybody And that includes things like board meetings have to be open. You have to provide for an owner comment period at the beginning of each board meeting. And no decisions other than ministerial decisions may be made outside of those board meetings. Working meetings, even if you're not going to vote on something, if it's the whole board or only the board that's meeting and you're talking about association business, that's a board meeting. There's also another part of the statute that specifically says that boards can't use social gatherings to avoid the open meeting requirement of the statute, right? If discussions on topics that are related to association business are happening outside of the owner's view, that is absolutely contrary to the legislative intent behind all of these meetings provisions that are taking effect in January for everybody. I think one of the things that we were talking about in discussion, when we were preparing for this meeting, is our recommendation. And let me take a step back before I even say that. For years, our firm has taken the position that transparency is a good thing. We've encouraged clients that aren't required to have open meetings to have open meetings anyways. And Wakaiowa has been in effect for 7+ years now for Wakaiowa communities, and they have all been subject to these very requirements. And they have been able to do business just fine and able to substantially comply with these statutory requirements without an excess of drama or without feeling hamstrung or like they're not able to do business. And our recommendation in general is try things that are consistent with the value of transparency that we know the legislature has emphasized here, instead of trying things to get around the value of transparency. And put differently, when you're experimenting and trying to or anti-transparency. If it increases transparency, then give it a try and see if it works in your community. If it decreases transparency, then it is likely not consistent with, at a minimum, the legislative intent, if not the actual language of the statute as well. Excuse me. And another thing that we have a bullet point on our list of things to talk about here is bad facts make bad law. Part of where some of this stuff is coming from is that there are individual owners that are in Olympia talking to their legislators about their perception that their boards are hiding things, that their boards are doing business behind closed doors, that the boards are resistant to requests to review association records, that the boards are trying to keep information from the ownership, right? That's the story that a lot of our legislators are getting in Olympia. And we don't want any of you to go out and engage in practices that create more bad facts like that and more stories like that to find their way back to our legislators to make that perception even stronger. So the best practice is to be transparent. If you're in doubt, ask your association attorney for how to handle a certain thing. Keep in mind that actual violations of statute may not be covered by D&O insurance. So don't sort of throw up your hands and be like, well, we're just going to do what we do. We've got insurance. If somebody sues us, it'll be fine. If you're knowingly violating a statute, you're likely not going to have insurance coverage for that. And I'm going to move us on to the next question because it's related so that we can keep talking on the same topic. So the next question that we have is, if boards used a chat board accessible to all homeowners at any time, potentially even providing alerts for new posts or comments, in order to discuss business and make decisions outside of meetings, could this be allowed under the new statutes? I am really struggling to wrap my brain around how anything can get done if everything has to wait for a meeting. Do you have any resource recommendations? So I think no. First of all, we've answered this question before, so for sure go back and look at our videos from the last couple of months on this topic. But to your question of whether this would be allowed under the new statutes, I think the answer is no, because a discussion on a message board is not a meeting, and board meetings are required under the statutes, and decisions are required to be made at board meetings under the statutes. So while there may not be, for example, a specific requirement that a board hold a meeting every single month, there is a specific requirement that substantive decisions have to be made at open board meetings. As to your comment about struggling to wrap your brain around how anything can get done, here's I have a whole lot of thoughts on this. Number one, like I said before, these requirements have been in place for Wakaiowa communities since Wakaiowa took effect in July of 2018. These requirements are not new for Wakaiowa communities, and Wakaiowa communities are functioning just fine. That's not to say that there aren't going to be growing pains, that it's not going to be an adjustment for communities that have always operated differently and now have to change, right? I want to recognize that that does represent a change. Change is always hard. Human beings are not wired for change. We do not like it. And so I want to acknowledge that it's going to feel weird and it's going to feel awkward and it's going to feel hard in the beginning. But it can be done, and it can be done, I think, far more easily than a lot of folks anticipate. I think a lot of people are anticipating, like, oh my God, open board meetings. Oh my God, owner participation forum. It's going to be a free for all. These are going to be 3-hour meetings. How are we going to get anything done? And so I want to bring us back to the reminder of what an open board meeting actually is. Okay. Under the statute, you guys are going to have to allow a 15-minute owner comment period at the beginning of every board meeting. So all your board meetings have to be open, meaning notice has to be given to your ownership of the meeting. And the first 15 minutes has to be reserved for an owner comment period. That does not mean that the rest of your board meeting or even the owner comment period is a free-for-all where owners get to interrupt, where they get to participate, where they get to, yell at the board or argue with things that the board is saying. And in particular, during the board meeting portion, meaning after the owner comment period is over, if you have an owner who continues to be disruptive during the board meeting portion of the meeting, you can remove them from the meeting. Whether that is physically because you're meeting in person, or whether it is just muting them or booting them out of the Zoom if you're doing it virtually. So there is a recognition in the statute that occasionally somebody might come into a meeting and be really disruptive to your process. You can remove that person from the meeting if that happens. After the owner comment period is over, there's no more provision for owner comments during the rest of the board meeting. So another thing that I think is worth saying, because, these questions are like the question about, like, what does ministerial mean? Or the question about, does having this message board comply with the statute? I think that the second question is easier to answer because the statute specifically does require that board decisions be made at a meeting, and a message board is not a meeting, okay? But the statutory change is new for non-Wakaiowa communities. It hasn't even taken effect yet, right? It takes effect January 1 of 2026. And we also don't have a lot of case law. In fact, I don't think we have any case law interpreting what exactly the legislature means by certain things. So until we have case law that interprets this, or until the legislature further refines and defines things, what we're left with is the plain language of the statute and with an understanding of the legislative intent, which is promotion of transparency, doing business in the view of the ownership, right? So anytime you're trying to figure out whether something technically complies with the statute and the statute itself is not crystal clear, your next question should be, is this thing going to promote transparency, or is it going to be contrary to transparency? And the reason why it matters is because most of my clients anyways don't want to be the test case, because what it takes to create case law around these issues is often an association getting sued because they did something wrong, losing or winning maybe at the trial level, and then one party or the other appealing the trial court decision so that the case goes up to the Court of Appeals. That is time consuming, and it is extraordinarily expensive. And even if you have insurance coverage that will pay for those legal fees, it will require a time commitment and an energy commitment from the board and from management, if you have management, that most clients don't want to touch with a 10-foot pole. So if you're excited about being a test case in that way, then sure, test the boundaries. But if you're not, the most risk averse way of approaching all of this is to ask the question of, is it allowed or prohibited by the statute? If the statute is unclear, is this consistent with or contrary to the value of transparency? And of course, also, whenever you're in doubt, ask your association attorney. So that's where I'm going to start with all of this stuff. I'm going to take a quick peek at the chat to see if there are follow-up questions. Jennifer, if you want to jump in with any additional comments while I'm doing that, please feel free.
Oh, I was popping in the chat while you were talking anyway.
Oh, okay, perfect. Okay.
There was one question about items that should not wait for the next meeting.
Okay.
And honestly, there are very few issues that cannot wait 15 to 30 days. If the board is conducting business reasonably, typically the management company, if you have a management company, there is authorization in the contract to pay regular bills as long as they're budgeted and contained within the regular budget. So if the board has delegated authority to an individual person, say the treasurer or the management company, to pay utility bills, pay vendors for work done, as long as the contract has been approved by the board and it's within the dollar amount set, that doesn't need to wait for a vote at a board meeting. The authority is delegated. It's already in board meeting minutes that the authority was delegated. It can just get done and be ratified at the next meeting. If you have an issue like a sudden water leak, delegate the authority for someone to get the leak stopped. And then once the leak is stopped, call a meeting. Or depending on where you're at in your meeting cycle, you can just wait for the meeting to review the bids. So it's not that no business can happen, period. It's that if the business is not routine and part of someone's delegated authority, it has to wait for the next meeting. And we're still hearing of associations that are only having quarterly meetings or bi-monthly meetings. I don't know of a way to conduct business reasonably without having at least monthly meetings.
I think that's part of the answer, right? Like, part of the answer to this question is, like, do you have any resource recommendations or strategies? Schedule more frequent meetings. I still have clients that are like, I just heard from a manager the other day that one of our clients is meeting twice a year, and they only do it in connection with their annual meeting and their budget ratification meeting. That association is going to be hamstrung from doing business unless their board starts meeting more often. And I understand the tension that exists with asking folks to meet more often, right? One more monthly meeting to add to the schedule. Everybody who is serving on a board of directors is a volunteer. Most of the volunteers who serve on the board of directors also have full-time jobs. They certainly have lives that are full and committed in many other ways. But I think this is going to be part of the answer, is to schedule meetings more often. And here's the thing: in order to hold a meeting, you have to give notice to your owners. You can cancel a meeting without giving 14 days notice of the cancellation. So put together an annual board meeting schedule that says the board is going to meet, the second Tuesday of every month at 7 o'clock in the cabana or the library meeting room, or wherever it is that y'all are meeting, or on Zoom. That's the other thing. The ability to do meetings virtually, I think, is a complete game changer in terms of the burden that's created by meeting monthly, when all you have to do is sit in your pajamas with a cup of hot cocoa in your chair and go nowhere to attend the meeting, right? Schedule meetings monthly, and if a month comes up where there's no business to be done at the meeting, then cancel the meeting, send out an email blast, post a notice on the association website or Facebook page or whatever to let people know that the meeting is canceled. But cancel the meeting. You can always cancel a meeting with less notice than you can schedule a meeting. So the other thing that I would like to say is one thing a board can consider doing as well is, actually back up before I forget, there are emergency provisions within Wakiowa that allow a board to take action either without a meeting or with shortened time notice, but only for very specific types of emergencies. So a failure to plan adequately is not an emergency under the statute. A failure to schedule regular board meetings and the desire to avoid having to do that, and then all of a sudden you get in a time crunch because of it, is not an emergency under the statute. But if you have a water leak, if there is a natural disaster, if there's a pandemic, if there's any of the things that we've all been through in the last 5 years that have created actual emergencies that would be recognized as an emergency under the statute, there are provisions for how you handle those things in, while holding the tension with this 14-day notice requirement for, giving owners notice of meetings. Another thing that I think you can do is, as a board, you can consider, and Jennifer touched on this briefly, but consider adopting policies that delegate certain types of authority to certain people to make decisions outside of board meetings. And this is not something new. If your community designates a certain board member to call the tow company and impound a car when they're parked in violation of the parking rules, you've already delegated authority in a manner that would be consistent with what we're suggesting here. So if you adopt policies and procedures that delegate certain types of decision-making authority to either your manager or an individual board member, but also adopt policies and procedures that will sort of turn certain types of decisions into ministerial decisions, then you can, certain types of decisions can then be made outside of board meetings. And again, like Jennifer said, what you do is at the next meeting, you ratify the decision and you place it in the minutes. Here's the thing, I think the bottom line with everything that we're saying here is that you act in good faith and you aim towards substantial compliance. And because we are all human beings, we are occasionally going to make a mistake and have an occasional issue that's handled in a way that is not compliant. But then you discuss that at your next board meeting. You create transparency after the fact by putting it in the minutes. And then also don't forget, there is that safe harbor in the statute where once the board has notified the ownership in writing of a certain decision, for example, by sending out the board meeting minutes to the ownership, owners have 90 days, I think. Is that right, Jennifer? 90 days under the statute?
It's
During
90
which they can sue the association to allege that that decision was improper. And once that 90 days has passed, they lose that right. So if you realize after the fact that, you made an insurance related decision outside of a board meeting that really wasn't ministerial, it really was substantive, at your next meeting, put it on the agenda, ratify the decision at the meeting, put that action in the minutes, mail out the minutes to your ownership, and start the clock ticking on that 90 days. I do not want to suggest, and I want to be really clear, that I think any community that starts operating in that way on purpose and trying to use that 90-day safe harbor as a way to sort of retroactively get approval for things that they're doing on purpose outside of board meetings to circumvent the transparency requirements. I think if you end up in court over a behavior pattern like that, you will find court orders entered against you so fast your head will spin. The legislature is not going to let a bad faith actor take advantage of that safe harbor. That safe harbor exists to protect board members who are acting in good faith, but who are human beings who just made a mistake and are trying to be transparent after the fact and fix the mistake. So I think probably we're 30 minutes in. We should move on to the rest of our questions. I think there might also be additional follow-up questions in the chat. If we have time at the end, we'll come back to some of those, but for now, we're going to move on.
I just wanted to, there's been two questions regarding what is ministerial.
Oh, yeah.
Just going back, we don't know.
The statute
This
doesn't define it.
the statute doesn't define it. There has been no case law, as Valerie said earlier. We don't know. But just taking the thread of what we've been talking about, ministerial means things that is not substantive, is not a new vote, is routine. So things like paying utility bills. You can delegate that authority to somebody, and as long as the utility bill is within a certain amount, it gets paid. If the board has already voted on a bid and has received the contract, reviewed the contract, approved the contract, signing the contract outside of a board meeting can be ministerial. So just as we said before, bad facts make bad law. And there's been a prior example of there's a 1-year limitation on challenging a declaration amendment that's found in 6434 and 6490. Several years ago, I can't remember when, there was a challenge. The amendment was outside the year, but the amendment was, there was fraud regarding that amendment. So I don't know, I can't remember the actual circumstances. If you want to know, you can look that up. But the court found that fraud is an exception. So if you're deliberately doing something to try and circumvent the law, as Valerie said, the court's going to overturn that so fast your head's going to spin.
Yeah.
So this is not an area where we want our clients or people in our practice area to make mistakes. Bad facts make bad law.
Jennifer, while you were chatting, I just looked at a couple of the follow-up questions, and I think we can cover a couple of them super fast. One is, what is the basis for your understanding that the meeting requirements are working just fine for Wakaiowa associations? My answer to that is we have dozens of clients that are Wakaiowa communities, and we get very few questions that are that suggest that this is problematic for them in any way. I assume that if for example, the owner comment period was a problem,
Oh,
we would be hearing about it because our clients call us when they have problems. So that's not to say that, again, not to say that there won't be growing pains. There aren't things about this that are going to be hard for those that are transitioning from a different way of doing business. But I think it illustrates that this can be done once you get through those growing pains. And there was another question about the 15-minute owner forum where the person said, I also thought members must be allowed to comment before every board vote. Is that not correct? No, it is not correct. The whole point of the owner comment forum being at the front of the meeting, at the beginning of the meeting, is precisely so that they get to comment before the votes start happening. So the idea here is you've got an agenda that owners know ahead of time what the board is going to be discussing at the meeting. They get their owner comment period at the beginning of the meeting. Once the owner comment period ends, then the sort of board meeting part of the meeting starts and you discuss and you take votes. You are not stopping every time you vote to get an additional owner comments before each vote. So that is not correct. And then finally, if there are no questions up front during the 15-minute open forum, does the board have to wait until those 15 minutes are up before starting their meeting? I think, this is going to be a your mileage may vary kind of thing. If nobody shows up or nobody signs up to comment, you can start the board meeting. But let's say 7 minutes in, a new owner walks in and they do want to make a comment. I don't want to be the lawyer in court arguing that a board saying they couldn't comment because they were late, even though they got there before the 15 minutes was over, is a reasonable choice, right? So whether you hold, whether you, let's say your board meetings are at 7 o'clock, whether you start the board meeting at 7:15 and you wait that 15 minutes every single time, or whether you start the board meeting 3 minutes in because nobody signed up, with the understanding that if somebody does come in and want to comment, you stop the meeting and allow them to do that. those are probably both reasonable options, but refusing to allow someone to comment because they're late, but within the 15 minutes, I think is the problematic choice to be made there. So Jennifer, why don't you take us away to the rest of the questions? And if we have time, we'll come back to more of these other ones.
Okay, excuse me. So our next question was, I was a little confused about your answer to a question in your webcast from October 22nd. It sounded like you said that contracts for bids were to be discussed in open board meetings. I was under the impression that contracts were only to be discussed and chosen in executive session. In the open board meeting, is there a vote for the contract at the quoted rate? Can you please differentiate? So, okay. What we're looking at is 6490-445 sub 2 sub B sub 4. And this specifically states that contracts, leases, and other commercial transactions to purchase or provide goods or services currently being negotiated to be discussed in executive session if premature general knowledge of those matters would place the association at a disadvantage. So you're not required to discuss bids and contracts in executive session. You can choose to, but these are bids and contracts that have not been decided on. So all votes must happen in an open meeting. Discussions with an architect to prepare a scope would not be done in executive session. Discussion about budgets would not be done in executive session. After bids are received, it may be appropriate to have executive sessions to negotiate the terms and item price, because that is currently a bid or contract under negotiation. Once the terms are finalized, the vote to approve that bid or contract must be done in open session. And you don't have to have executive sessions. Excuse me. This is something that the legislature has carved out, allowing these particular topics to be discussed in behind closed doors, because number one, it may harm the association's position, or number two, it may violate somebody's privacy. So just because you can doesn't necessarily mean that you should. The board should always be thinking about what is reasonable. Will this hurt any individual? Will this hurt the association? And then also, what gives owners the most transparency? Because at the end of the day, you're all owners. You all have the same skin in the game, as it were, because you all own your homes within this community. So if there's no reason to have behind closed doors that we're going to accept X bid for landscaping, or we're renewing X contract for landscaping, the vote for that must happen in open session. You don't necessarily have to discuss it behind closed doors. Valerie, did you have anything to add?
No, I think you covered it. Thanks, Jen. All right, here's our next question. For condo association budget ratification meetings, do owners planning to vote no have to be present when the meeting is called to order? So the provisions that we're talking about here in terms of the statute are RCW 6490, 525, and 445. Those are the budget ratification and the meeting sections of the statutes. Owners that wish to reject the budget have to be in person by present or by proxy or by absentee ballot. The association, however, does not have to provide absentee ballots, and it does not have to provide and prepare proxies, but it must ensure that any proxy submitted complies with the proxy section of the statutes. The thing is that there's no way to know ahead of time when during the meeting the vote is going to take place. So it would be better to be present for the entire meeting. However, we would tell a client to count the votes that are present at the time the motion is made to reject the budget, if such a motion is made, not to count only those that were present at the beginning of the meeting. If there is no quorum at the beginning of the meeting, keep in mind the meeting can be adjourned and that budget will be automatically ratified. You cannot take a vote of any kind without a quorum. So in order to reject a budget, you have to first make quorum and then make a motion to reject the budget. If there is no quorum at the beginning of the meeting would be adjourned, the budget would be ratified, no vote would take place on rejecting the budget. In general, our approach is that we promote procedures that would allow members to vote on issues, and we generally disfavor approaches or efforts to reject votes based on a sort of meaningless technicality. So the idea that you shouldn't be able to vote because you were 5 minutes late to the meeting, even though you were there by the time the vote took place, is not something that we would support. We also, however, would not support collecting votes following the meeting and trying to like rewrite history after the fact. So if the owners are present when the vote takes place, they should be allowed to vote. If somebody shows up with a proxy, as long as it complies with the statute, they should be allowed to cast the vote based on that proxy, as long as it's a valid proxy. We think that making sure that the proxy complies with the law is fine, but looking for nitpicky ways to reject votes is not something that we support. And I think that covers it, but Jen, if you have any comments, please feel free to step in.
No, there seems to be a lot of confusion regarding ratification still. And as Valerie said, as long as a majority of the owners don't reject the budget, it's ratified. So if a majority of the owners are not present in person or by proxy at the meeting where the budget is up for ratification, it's automatically ratified. So moving on to our next question, is it legal to pay income tax on reserves CD earnings from the reserves fund since that income is strictly caused by reserve investing? There's no change in federal taxes since everything is taxed at 30% flat rate if you're filing 1120H. So this question typically comes up several times towards the end of the year. Typically, income tax on reserves is paid from the operating account, as it is income to the association. So any income from the reserve investments should go first to the operating account, then be moved back to reserves. A portion for taxes can be held from the interest income before the transfer to reserves. The transfer is to reserve a budget estimate only until the actual transfers to reserves are made. Statutes are silent on how interest and taxes are handled. Your accountant can have some opinions on this as well. So honestly, listen to your tax preparer or your accountant, but generally income tax from reserves is paid out of the operating account, and then that income is moved back to reserves. Valerie, did you have anything to add to that?
Nope, that's it. You covered it.
Okay, so our next question. If a condo owner wants to make modifications or remodel their unit, do they need to submit an architectural control committee form to get HOA approval? And how does the ACC process typically work? So we can't answer this particular question completely because it depends on the individual association. There are many different forms of condominiums. There are many different types of procedures and processes for owner modifications. So it really depends on your particular association's governing documents and procedures. So in general, if the remodel involves anything regarding structure, plumbing, electrical, perimeter drywall, and multifamily housing, HVAC or mechanical, more likely than not, it will need approval by the board or ACC if you have one. These particular projects also typically require permits from your city or county. So when these particular things are, particular projects are contemplated, double check with your association on what they want to see. You can ask, do you want information regarding finishes? Do you want contractor information? Do you want insurance information on the contractor being used? Anything like that is probably part of the modification request that needs to be submitted to the board or ACC. Again, types of modifications, locations of modifications, materials used, vendor used, permits being pulled. These are all things that the association needs to know. If you're in multifamily housing, double check about the writers on the vendor's insurance. Many vendors have a rider stating that the vendor's insurance will not cover multifamily housing. Some condo declarations have specific provisions regarding owners' rights to modify and procedures to do so. Anything in the declaration overrides adopted rules. So the association or ACC will review the submission and ask questions if needed. The request is approved, rejected, or asked to be resubmitted with modifications. So that's just in general a quick blurb on how that works. But each individual association is different. If you have questions, talk to your association. Valerie, did you have anything to add?
Nope, I think you covered it. So I'm going to move us on to our next question, which is, since our meetings are held virtually and voting for other matters is conducted online, how do homeowners reject a proposed budget under RCW 6490-525? There was also a whole list of more specific questions included with this one, but I'm not going to read all of those out because we cannot give legal advice about how to vote for any particular community in this forum. What I can tell you is, well, a couple of things. First of all, we have gone over the whole process of budget ratification several times over the past few months and even more times over the last couple of years. And in particular, we actually did a 1-hour Zoom presentation about how to properly ratify a budget. I think we did that like 3 years ago, maybe 2 years ago, something like that.
It
It's
was October 5th. I'm sorry, I remember that date because it's my dad's birthday. So it was October 5th, I think 22 or 23.
So it's probably going to be the oldest available video in our Zoom, our YouTube channel. So if you go to our YouTube channel and you just scroll to the oldest available video, it's probably going to be our little 1-hour class that we did about how to ratify a budget. That would include information about how to reject a budget. But I can tell you that under the statute, 6490-525, again, is the statute that we're talking about. And it specifically says that unless, quote, the unit owners of units to which a majority of the votes in the association are allocated, or any larger percentage specified in the declaration, unless that number of owners or that amount of the voting power votes to reject the budget, it's ratified. So most online voting platforms will have a yes and no option for voting, but also a lot of communities, and this is typically how we advise our clients, that you don't actually call for a vote to ratify the budget because the automatic default option is that it's ratified unless it's rejected. So in order to reject a budget, and without commenting about your specific association's voting procedures and practices, what would need to happen is somebody would have to make a motion to reject the budget. Somebody else would have to second that motion. And then there would be a call for votes on whether to approve the motion to reject the budget or whether not to approve the motion to reject the budget. If voting is taking place at a meeting, including over Zoom, again, a majority of the voting power in the association has to be present in order to reject it. You have to have a quorum in order to take a vote like that, for example, to begin with. But it's not just a majority of who's at the meeting or who's voting at the meeting. It's a majority of the voting power in the community that is required to reject a budget. Again, if you have no quorum, if you don't have that majority of the voting power in the community to reject, then it's automatically ratified. Generally, when it comes to methods of voting, we recommend that whatever you choose, it be convenient to the owners, that it not be confusing, that it be something relatively easy for your owners to execute. And we, again, as we said earlier today, recommend against adopting procedures that make it difficult for owners to vote, especially if you're doing that just to prevent a budget from being rejected. Because here's the thing, the worst thing that happens if your budget is rejected is you default back to the previous year's budget. So it's not that you have no budget, it's just that you default back to the previously approved budget. Um, so I think that covers that one. Jen, if you want to add anything, feel free.
Nope, I think you handled it. So our last prepared question, and we may have time for a little more. So if you have any questions, feel free to put them in the chat. If we don't get to them, we can add them as seed for next week. So our last question that was prepared ahead of time, if an owner moved into an upstairs unit with hard surface flooring and later found out that the flooring was installed improperly or without approval, can the association request they revert it back to the way it was? So we can't answer this question completely because it would be giving legal advice. It really depends on the individual situation. As a general rule, associations cannot enforce the governing documents against a new owner for an old owner's activity unless that particular owner, the new owner, had notice, typically in the resale certificate, that there was an unauthorized modification, or how they have to have actual notice that there is a condition that they could be enforced against. So as a general rule, regardless of who put the flooring in or how the flooring was put in, noise created by hard surface flooring may be a violation of the governing documents. So it's typically more a noise issue than the actual flooring issue. So if the new owner puts down area rugs or slippers, what have you, and mitigates that noise, there's no reason for the association to enforce against that new owner. It's not the flooring that's at issue, it's the use of the flooring. Now, we've run into this question so many times with clients. We've had one particular client where a unit owner wasn't it about $8,000 in fines, Valerie, for that particular issue because they installed hard surface flooring without approval and refused to mitigate noise.
I don't remember, but that would not surprise me, just given how pervasive the noise issues with things like this can be.
Yeah, so it happens, but as a new owner, actually, let me take a step back from that. As an association, when a unit is up for sale, most associations don't have the authority to inspect units. So take a look at the listing. Do you see anything that doesn't comply with the association standard? Was there a remodel done? We've had associations where people have removed walls without approval and put the unit up for sale. We've had associations where an owner installed a loft without approval and it sold before the association could start any enforcement process. So the new owner the association had to pay for the structural engineer to come in and see if it was actually compliant, which it wasn't. So when a unit is for sale, double check the listing, see if the owner will allow you in to see the unit. Make sure that any non-conforming modification you put on the resale certificate that there's an unauthorized modification. That notation on the resale certificate allows the association the authority to then deal with that owner while the unit is up for sale, and then also continue with the purchaser so that the modification can be brought to standard. Without having that notation on the resale certificate, it's extremely difficult to prove who knew what when. Valerie, did you have anything to add to that?
I don't, and I do think we have time to get to a couple of questions from the chat. So I'll start with the most recent one first, and then I'll go back to an earlier one. Can a renter from our condo community be a member of the board? And as Jennifer noted in the chat, the qualifications for service on the board are typically found in the governing documents for each community. And so you need to look at your articles of incorporation, your declaration, and your bylaws. Often people think, oh, that should be in the bylaws. Yes, it should. Sometimes it's in a different place. So don't just look in one place. If there is not a restriction or a requirement in your governing documents that a board member must be an owner, then it is not unheard of for tenants to serve as board members. We have a tenant actually in one of our communities that has lived in the community for, I don't know, 20 years and has been a member of the board for something like 15 of those years. So it's not uncommon. It does happen occasionally, but it's not permissible in every community. And sometimes the qualification isn't like, in order to qualify to be on the board of directors, you have to be an owner. Sometimes it's as simple as saying the board is composed, or the board must be composed of 3 members or 3 owners, for example. The board must be composed of 3 members who are owners or whatever. So sometimes it's not very clearly called out as a qualification. And I would suggest that you have your association attorney look at your governing documents to give you an answer whether a tenant can serve on the board in your particular community. Another question that was in the chat was a follow-up to all of the meetings discussion earlier on. This one says, if the association has approved the management company to approve vendors, projects, etc., up to a certain dollar threshold, does that mean the management company can move forward between meetings as long as they stay under that? I'll give my thoughts on this and then ask Jennifer to jump in with anything additional. A lot of management contracts actually will say that the manager can pay bills up to a certain dollar amount. And simply approving that contract, I don't think is enough to allow the manager to go out and willy-nilly hire vendors and do projects that aren't specifically approved by the board. If the board adopts a policy that says these types of projects under these dollar amounts can be decided upon by the manager in between meetings, I think a specific policy like that calls out exactly what is and what isn't something the board contemplates the manager being allowed to do would be better than something more vague and less specific. Jennifer, did you have any thoughts to add on to that?
Just briefly, and it makes sense to have the management company seek out bids for certain projects. The board can allow them to approve a bid, as Valerie said, with very specific parameters. But also remember that any of these actions have to be ratified at the next board meeting.
Yep.
So if the management company goes out and follows the procedures the board has laid out, approves a vendor, gets a bid, and gets some work done, that project, the discussion regarding that project, what that project was, goes on the meeting minutes for the next board meeting, and the board can ratify that decision. So frankly, it would make sense for a board to say, okay, we have the arborist gave us a bid of X to remove this tree. As long as the cost comes in at X, management go ahead and approve it. We're fine with it. And then it's done. So again, what's reasonable? And make sure everything is on board meeting minutes, because if it's not written down, it didn't happen.
Correct. And one other thing I'll add, I guess, is again, if you're looking at this as a way to reasonably move things forward within your community with as much disclosure and transparency as possible in each board meeting and other communications with your ownership, that's one thing. If you're looking at this as a like, how much business can I shove out of board meetings so we can meet as infrequently as possible while still technically being in compliance with the statute? And I'm certainly not suggesting that that is what the person who posed this question is contemplating. But again, what's your intent? Are you complying with the statutory intent of transparency? Are you looking for ways to comply with that statutory intent, or are you looking for ways to get around that statutory intent? Those are the questions that I would want my clients asking when they're making these decisions. And that takes us right up to 11 o'clock. So we are done for today. Thank you for joining us, and we will see you guys back here next week. Thanks, everybody.
Thank
Bye.
you.